What's going on, guys? It is the Bad Wolf, and welcome to Chapter 7 of the Treatise or a Treatise on Federal Income Tax or Income Tax Laws. We got the treaty, so if this is your first time here, well, you picked a hell of a time to jump in, but the water's fine. In this particular video, the man who created Black's Law Dictionary, okay, Henry Campbell Black, he created this treatise for tax. Who would have known? Just happened to be a little something, something I stumbled across. And in here, he's breaking it down what is taxable and what's not taxable. Who's taxable? Where's your income, your source derived? Where are you located? All that good jazz. It's about 433 pages roughly. Um, so we're going through it chapter by chapter, and we're on 7. We're almost halfway through. But if you guys want this document, feel free to go over to blacksite32.com, check out page 2 of the free documents. It'll be the latest or the last file on there. You might want to get it for yourself. I'll be making my own version of it for those people who don't want to read through the whole thing. Um, let's get going.
Tax. Chapter 7 Exemptions and Exceptions, Section 76. Revenues of United States. 77. States and Municipal Corporations. 78. Agricultural and Horticultural Organizations. 79. Labor Organizations. 80. Fraternal Orders and Benefit Societies. 81. Religious, Charitable, and Benevolent Associations. 82. Educational and Scientific Institutions. 83. Building and Loan Associations. 84. Savings Institutions. 85. Civic Organizations and Chambers of Commerce. 86. Income from property otherwise taxed. 87. Proceeds of life insurance policies. 88. Exemption of fixed amount of income. Section 76. Revenues of United States. The legislature of Wisconsin, in enacting the income tax law of that state in 1911, was at pains to exempt from taxation under the statute income received by the United States. But a similar exception would be necessarily implied in any tax law of any state. In the federal income tax law of 1913, the precise point is not covered, but it is a fixed principle of statutory construction that the sovereign or government is never included within the scope of a statute imposing taxes unless expressly named. Besides, the government of the United States could not properly be described as a person, a citizen of the United States, or a corporation, joint stock company, or association. This point might be of practical importance in its application to the case of a federal officer receiving fees for services or a postmaster taking in money from the sale of stamps. If the receipts of the office or fees constitute the officer's compensation, they are a part of his private income and may be taxable, but if he is paid a salary and required to turn in the fees or receipts of his office to the Treasury, such monies are public revenues and not taxable. Point 1 Section 77. States and municipal corporations. It is not within the constitutional authority of Congress to lay the burden of federal taxation upon the revenues of a state or a municipal corporation, at least in so far as the same are raised by the ordinary methods of state and local taxation, or accrue from property owned or money invested by a state. Thus, it has been held that the word corporation in an internal revenue law does not include a state, so that a railroad wholly owned by a state, managed by state agents, and the profits of which form a part of the revenue of the state, is not liable to taxation under such law. Point 2. So also, a municipal corporation is, at least in its political aspects, a portion of the sovereign power of the state, or a depository thereof, and therefore is not subject to taxa taken by Congress upon its municipal revenues. Point 3. But the exemption of a state from taxation extends no further than the functions belonging to a state in its ordinary capacity, the exemption of sovereignty being limited by the attributes of sovereignty. Hence, if a state unites in one undertaking an exercise of the police power with a commercial business, as in the case of the South Carolina dispensary law, where regulation of the sale of intoxicating liquors was effected by the state itself engaging in the business and monopolizing the traffic, the United States cannot be compelled to aid the operation of the police power by foregoing its right to lay an impost or excise tax on the business part of the transaction. And hence, the agents of the state government employed in the operation of the dispensary law were held leo 1 supra, Section 64. 2 Georgia v. Atkins, 35 Ga. 315, 1 Ab. U.S. 22, Federal. Gas. Number 500 to pay the internal revenue tax imposed by the Act of Congress. Point 4, and the Supreme Court of the United States has also ruled that a municipal corporation engaged in the business of distilling spirits is subject to internal revenue taxation under the laws of the United States, whether its acts in that respect are or are not ultra vires. Point 5, it was probably with a view to just such cases as these that Congress, in the income tax law of 1913, has expressly disclaimed the intention to apply the statute to the revenues of states or municipal corporations. Subsection G, Clause A at the end. See Appendix. It is undoubtedly within the power of a state to tax the revenues of its own municipal corporations if it shall see fit to do so. And so far as concerns income taxation, the principle appears to be that profits derived by a municipality from anything outside the scope of its ordinary and necessary municipal functions, and in the nature of a business enterprise, will be subject to the income tax. Thus, in England, a municipal corporation owning and operating its own system of waterworks for distribution to its inhabitants is held not taxable on the income derived therefrom. 6. But it is liable to assessment in respect to surplus revenue derived from supplying water beyond the area of compulsory supply and from the sale of water for the purposes of trade or manufacture. Point 7. So also, a municipal corporation is subject to taxation upon profits derived from the maintenance of a market or a market hall. Point 8. And in a case where a quasi-mu * South Carolina v. United States, 199 U.S. 437, 26 Sup. CT 110. 50 L. Ed. 261, 4 a.m. And ENG. Ann. Gas. 737, S. Salt Lake City v. Hollister, 118 U.S. 256, 6 Sup. CT. 1055, 30 L. Ed. 176, O. in Re Glasgow Corporation. Waterworks, 12 Scotch Law Republic. For 66, 1 Tax Cass. 28, 7 Glasgow Corporation. Water Commerce v. Miller, 23 Scotch Law Republic. 285, 2 Tax Cass. 131. S. in Re Birmingham Corporation, 1 Tax Cass. 26, Attorney General v. Scott, 28 Law T. 302, 1 Tax Cass /55. BL. Inc. Tax. 11, 161. Municipal corporation had constructed and was maintaining a sewer, the funds being raised by a public loan repayable in annual installments, and the money for such repayment was found partly by contributions levied from neighboring district councils, whose sewage went through the sewer, and partly from rates, and this was the only income, it was held. Nevertheless, that the corporation was liable to the income tax. Point 8, it was ruled by the officers of the Treasury Department that a municipal corporation which owns and operates its own waterworks, or a plant for the production and distribution of gas or electric light to its citizens, was not subject to the corporation tax under the Act of Congress of 1909, although it makes and collects fixed charges for the service so rendered and derives a profit therefrom. But this was on the explicit ground that a municipality is not a corporation organized for profit or one having a capital stock represented by shares. Within the language of that statute. Point 10, such questions are by no means free from doubt. but they are not of great practical importance at the present time, since the modern income tax laws generally exclude municipal corporations, either expressly or by the use of language which cannot be held to include them. Thus, in Wisconsin, the statute exempts income received by the state and all counties, cities, villages, school districts, or political units of.
Now, why doesn't it apply to them? Because they're not operating per se, per se, as a corporation. They're operating as their own lowercase g government, and they are their own taxing authority. So, though they are part of the public, by their legal definition, they are not for profit. But we know they are. So, it's a play on words. Or they could be privately classified as a political unit, not directly subject to the government's tax, and once again, their own taxing authority. But their tax is looked at as internal. This is a membership fee. We can tax our own members and our own PMA. Either way, you see what they're doing.
The state. In South Carolina, the statute is made applicable to persons and citizens of the state, but expressly excludes all corporations. In Hawaii, the phrase employed is more ambiguous, but a municipality could hardly be described as a corporation doing business for profit within the territory.
See?
9 Istradifav and Pontypridd. Section 78. Agricultural and horticultural organizations following the language of the Act of 1909, the Income Tax Law of 1913 specifically exempts from its operation agricultural or horticultural organizations. The phrase has not been judicially construed by the courts, but several rulings of the Treasury Department have indicated its meaning, as viewed by the officers charged with the administration of the law. Agricultural organizations, it was ruled, do not come within the statutory exemption unless their chief object is the promotion or advancement of agricultural interests and no part of the income inures to the benefit of their stockholders. A corporation engaged in agricultural, horticultural, or similar pursuits, evidently for profit, is not. Within the meaning of the law, such an agricultural or horticultural association as is specifically enumerated as exempt from the requirements of the Act cited. Corporations, to come within the exempted class, must be such associations as, by means of exhibits, contests, awards, and premiums, are designed to encourage better production of agricultural or horticultural products, not themselves engaged in agricultural or horticultural pursuits, such as county fairs and like organizations of a quasi-public character, whose income, derived from gate receipts, entry fees, donations, etc., is used to meet the necessary expenses of the association, the payment of premiums, making improvements, etc., no part of which income inures to the benefit of any private stockholder or individual. A corporation engaged in the business of raising stock or poultry or growing grain, fruits, or other products of this character is an agricultural or horticultural society only in the sense that it indicates the kind of business in which it is engaged. If the business of the corpora so engaged is so carried on that its income inures or may inure to the benefit of its stockholders, it will be held to be a corporation organized for profit and, regardless of the fact that it may be engaged in agricultural or horticultural pursuits, it must make returns of annual net income for each calendar year and pay any special excise tax to which such returns may show it to be liable. X1 Thus, fruit growers' associations whose purpose is to promote the mutual benefit of their members in growing, harvesting, and marketing their products, and which are not organized for profit and have no capital stock represented by shares, and whose income is derived wholly from membership fees, dues, and assessments to meet necessary expenses, are not liable to the tax. Point 12. but on the other hand, corporations owning sugar or other plantations and disposing of the products thereof are not entitled to the exemption simply in view of the nature of their business. Point 13. And corporations engaged in growing fruits, vegetables, and like products for profit, and which distribute such profits among their members on the basis of the capital invested, are liable to the statute, and must make returns and pay the taxes, if any are found to be due. Point 14. Section 79. Labor organizations. A specific exemption is made in the federal income tax law in favor of labor organizations. This phrase is not elsewhere defined in the Act, but the intention of Congress in this behalf is plainly indicated by the events of political history and the trend of legislation in recent years. The term labor, as here used, evidently cannot be taken in the rather wide sense given to it in some other phrases familiar in the law, such as work and labor, common labor, worldly labor, and the like. But the organizations referred to are those associations of mechanics and artisans, and even of unskilled laborers, which are formed for the purpose of the mutual advantage and protection of their MEM 11 Treasury decisions. No. 1737, 12 Treasury decisions bears for enforcing the regulations which they prescribe with reference to the conditions and hours of labor and the rate of wages and other such objects, and which are commonly called trades unions or brotherhoods, federations, guilds, or unions of the mechanics employed in any given trade or craft. Though such associations are not explicitly exempted in the income tax laws of the states, they do not ordinarily come within the definition of the kinds of corporations which shall be taxable, or else they fall within the terms of a general exempting clause, as in Wisconsin, where the statute exempts associations of individuals not organized or conducted for pecuniary profit. Section 80. Fraternal orders and benefit societies. There is also a specific exemption in the Act of Congress in favor of fraternal and beneficiary societies, orders, or associations operating under the lodge system, and providing for the payment of life, sick, accident, and other benefits to the members of such associations and dependents of such members. As here used, the word lodge means the meeting place, and hence the meeting itself or the aggregate of the members of a secret society or fraternity. Point 15. Such bodies are very numerous in the United States, and for the most part they combine with their social, moral, or philanthropic objects the grant of pecuniary relief to sick or disabled members and to the families of deceased members. Many are in fact but mutual insurance associations, their revenues being derived from entrance fees, membership dues, and occasional assessments levied on the members and expended, over and above the cost of management and other small necessary expenses, in the payment of sick, accident, and death benefits. The officers of the Treasury Department have ruled that such an association, if it does not, Oper 15 State v. Farmers and Mechanics 8 under the lodge system, is simply an insurance company and subject to the tax, notwithstanding that all its funds are derived from membership fees and assessments and expended in the payment of such benefits. Point 16 Section 81. Religious, charitable, and benevolent associations. The Act of Congress also exempts any corporation or association organized and operated exclusively for religious, charitable, scientific, or educational purposes, no part of the net income of which inures to the benefit of any private stockholder or individual. And the statute of Wisconsin exempts any association of individuals organized for religious or benevolent purposes and not organized or conducted for pecuniary profit. The rules with reference to the exemption of such associations from the burdens of ordinary taxation have been well worked out by the courts and will generally be found applicable in the case of the special tax here under consideration. Specifically with regard to the corporation excise tax of 1909, it was ruled that a charitable institution was exempt whether it was supported by voluntary contributions or by state appropriations. Point 17 in England. The rule has been stated that, in the income tax law, the words charitable purposes are to be interpreted not according to their popular meaning, but according to their technical legal signification, though it was held in the same case that the phrase would include a home or asylum for the maintenance of single persons and widows belonging to the Moravian Brotherhood. 18, and it is a general rule in the construction of exemptions from taxation that the word charity is not to be restricted to the relief of the sick or poor, but extends to any form of philanthropic endeavor or public, i.e., Treasury decisions. No. 1738. If Treasury decisions, no. 1742 par. 4 is income tax, RSV. Pemsel 1891 App. Cass. 531. 3 tax gas. 53. Beneficence. 19 and even under the more restricted form of exemption under the tax laws of some of the states, extending to public charities or institutions of purely public charity, it is held that the term public is not equivalent to universal. The exemption would not apply to a charity limited to a certain class of privileged individuals. But on the other hand, it need not be open to all persons alike, for the public to which it administers relief may be limited to the inhabitants of a given city or other place, or may be restricted to the sufferers from particular diseases or forms of need, or with reference to nationality, color, or religious connections. 20. Also, it is a well-recognized rule that an institution, such as a hospital or asylum, does not lose its character as a charitable institution because it receives pay patients, or in other words requires those of sufficient pecuniary ability to pay for the accommodation and treatment which they receive, if the income must derived is not distributed among the corporators or stockholders, but applied exclusively to the purposes of the institution, and if, at the same time, poor or indigent patients are received and treated without charge. 21. But an English decision holds that if a hospital takes paying patients at remunerative prices and applies its surplus income to the extension and improvement of the hospital buildings, the Surrey C. Gerke v. Purcell, 25, Ohio Street. 229, Cleveland Library Association v. Pelton, 36, Ohio Street. 253, State v. Academy of Science, 13 MO. App. 213, Massachusetts Society v. Boston, 142 Massachusetts. 24, 6N. E. 840. 20 Bangor v. Masonic Lodge, 73 Me. For 28, Bird Orphan Asylum v. Plus is profit and assessable for the income tax. 22 The business of maintaining a cemetery, from which revenues are derived in the form of cash for the sale of gravesites or burial lots and annual dues or assessments upon lot owners for the care of the grounds, is not a charity, and a corporation owning and conducting the cemetery is taxable on the income derived from it. 23, but the federal income tax law of 1913 contains a specific exception in favor of cemetery companies organized and operated exclusively for the mutual benefit of their members. Section 82. Educational and scientific institutions. The Act of Congress exempts corporations organized for scientific or educational purposes, and that of Wisconsin Scientific and Educational Associations. It has been held that a provision of an income tax law exempting from its operation private schools, colleges, and other educational institutions does not make an illegal discrimination, such as to render the law invalid as to other corporations or persons upon whom the tax is imposed. 24 But it seems clear that a private school, in which tuition fees are charged, and from which a revenue is derived over and above the expenses, would not be exempt under either of the provisions quoted. Since the federal statute applies only to educational institutions, no part of the net income of which inures to the benefit of any private stockholder or individual, and the state law applies to such institutions only when not organized or conducted for pecuniary profit. On the other hand, the exemption under these statutes is a Par 22 St. Andrews Hospital v. Shearsmith, L. R. 19Q. B. Div. 624, 2 Tax Cas. 219. 23 Paddington Burial Board v. Commerce of Inland Revenue, L. R. 13Q. B. DIV. 9. 2 Tax Cas. 46. Paisley Cemetery Company. Etly broad enough to include various kinds of institutions which derive their current revenues partly from endowment funds and partly from small charges to the public for admission to their buildings or for the use of their privileges, such as art galleries, museums of curiosities or antiquities, academies of the fine arts, institutions for the exhibition of objects illustrating the natural sciences, public libraries, and the like. In the general law of taxation and with reference to exemptions, there has been much doubt as to whether such institutions could be classed as schools, institutions of learning, purely public charities, or the like. Point 25, but under the income tax laws, the test is in the question whether or not they are conducted for profit, or whether or not any part of the income is distributed to the proprietors, corporators, or shareholders as a gain or profit. And on the analogy of many similar cases, it would seem that the mere fact of admission fees being charged would not make them institutions conducted for profit if the revenue so obtained is applied to the upkeep or expansion of the institution, rather than to the benefit of any private person interested in it. Section 83. Building and Loan Associations. Domestic building and loan associations are exempt under the Act of Congress of 1913 when organized and operated exclusively for the mutual benefit of their members, following the language of the Corporation Tax Law of 1909. And a similar exemption is found in the Wisconsin statute. It was ruled by the Treasury Department that building and loan associations are not exempt if they loan money to others than 26 Academy of Fine Arts v. Philadelphia County, 22 Pascals. St. For 196, Gerke v. Purcell, 25, Ohio Street. 229, Salem Lyceum v. Salem, 154 Mass. 15, 27 N. E. 672, Mercantile Library Company v. Philadelphia, 14 Pascals. Company. CT. R. 204, Cleveland Library Association v. Pelton, 36, Ohio Street. 253, Philadelphia Library Company v. Dono Huff, 12 Philadelphia. Pa. 284, Manchester v. McAdam, 1896 App. Cass. 500. Their members, thus doing a business similar to that engaged in by banks and trust companies. It is also held that building and loan associations which receive sums of money on deposit, which is not in payment of stock, and on which the depositor receives a fixed rate of interest, regardless of the earnings of the association, are conducting a business similar to a banking business and are therefore subject to the special excise tax on corporations and should be required to make a return showing their net income. 26. It was likewise held that such associations, providing for the loaning of funds to non-members, for issuing preferred or guaranteed interest-paying stock, and allowing directors to cancel outstanding certificates of general stock not borrowed upon, paying the holder the book value of stock canceled, thereby being authorized to retire any and all stock in their discretion, are not exempt from the tax. Point 27, but it was held in a later case that, when a building and loan association is organized under the New Jersey statute solely for the purpose of making building loans to its members, who are entitled to vote in the management of the association's affairs, according to membership and not by virtue of stockholding, it is an association for the mutual benefit of its members, within the meaning of the statute, although under its plan of operation, there may be inequality in the returns to the prepaying stockholder, etc., since the word mutual is not to be taken as synonymous with equal. Reference was made to the decision above cited, but it was said, that case does not appear to be applicable. The shareholders in that association voted for the directors by the share, thereby affording opportunity for a few individuals, by the acquisition of shares, to control the policy of the association. The funds of that association appear to have been a subject of loans to any borrower, without respect to member 26 Treasury decisions, No. 1655. 27 Pacific B. and L. Association v. Hartson, 201 Federal, 1011. Ship in the association, and there was a provision for the cancellation of outstanding certificates of stock not borrowed upon whenever the board of directors deemed advisable to pay the holder the book value of the stock so cancelled. In almost every aspect, the case cited on behalf of the collector is not applicable to the present case. 28 Section 84. Savings institutions in Wisconsin, mutual savings associations, are exempt from the payment of the income tax. Whether or not an institution exercising some of the functions of a bank is to be classed as a savings bank, savings institution, or savings association must be determined not by the name which it assumes or by which it is chartered, but by its organization, powers, and mode of doing business, as provided in its Articles of Incorporation. 29, and the phrases above quoted do not apply to every bank merely because it receives deposits of savings. The kind of associations intended by the law in Wisconsin are those which are operated exclusively for the mutual benefit of the depositors, who alone, and not any stockholders or proprietors, are entitled to participate in the profits. Such associations are authorized under the laws of numerous states, as for example, Massachusetts, where they are thus described: a savings bank, as existing in this state, subject to the general laws, is an institution for the purpose of receiving deposits for the benefit of depositors, investing the same, accumulating the profits or interest thereof, paying such its or interest to the depositor, or retaining the same for his greater security. There is no capital stock and no stockholders who are entitled to receive profits from the business, but its affairs are administered by a board of trustees. The securities in which the deposits shall be invested are prescribed by law, and the conduct of its affairs is under the supervision Parkview B. and L. Association v. Vision of a public officer. 30. So, in New Jersey, it is said that a savings bank is a quasi-charitable and purely benevolent institution, its only object being the safekeeping and provident investment of the funds of the depositors. The members of the corporation have no property interest in its funds, of which they are by law constituted the managers and guardians. The depositors, who alone are beneficially interested, have no voice in the management, nor even in the selection of the persons to whom the management is entrusted. Savings banks have no capital stock. They are incorporated and organized, not for the benefit of the corporators, but solely for the advantage of their depositors. 31. Also, under the federal income tax law of 1913, there is a special exemption in favor of mutual savings banks not having a capital stock represented by shares. Section 85. Civic organizations and chambers of commerce. It is specially provided in the federal income tax law that its term shall not apply to business leagues, nor to chambers of commerce or boards of trade, not organized for profit or no part of the net income of which inures to the benefit of the private stockholder or individual, nor to any civic league or organization not organized for profit, but operated exclusively for the promotion of social welfare. A board of trade, as the term is used in America, is an organization of the principal merchants, manufacturers, tradesmen, etc. of a city, for the purpose of furthering its commercial interests, encouraging the establishment of manufactures, promoting trade, securing or improving shipping facilities, and generally advancing the prosperity of the place as an industrial and commercial community. 32. Exactly similar organizations are sometimes called so Commonwealth v. Reading Save Bank, 133 Massachusetts. 13:43 a.m. Republic. For 95, S.I. Barrett v. Bloomfield. Chambers of Commerce, and the two terms are frequently stated to be synonymous. 33, but more strictly speaking, one of the objects of a chamber of commerce is to promote convenience or facility in buying, selling, and exchanging commodities. If these commodities include stocks, bonds, and other securities, the body practically fulfills the functions of a stock exchange. And in fact, in some cities, the stock exchange is officially denominated the Chamber of Commerce or the Board of Trade. If, in this sense, it is organized for profit or has a net income which inures to the benefit of the members, it is clearly not within the exemption, but is subject to taxation under the Act. Section 86. Income from property otherwise taxed in the several states, particularly Massachusetts, North Carolina, and Oklahoma. The law specifically exempts from the income tax such income as FS derived from property, which is itself subject to a tax or on which a tax has already been paid. For the current year, the Wisconsin statute contains the following provision: any person who shall have paid a tax upon his personal property during any year shall be permitted to present the receipt therefor to, and have the same accepted by, the tax collector to its full amount in the payment of taxes due upon the income of such person during said year. But one who claims exemption from an income tax on the ground that his income consists of or is derived from property not liable to taxation must affirmatively show that such is the case. 34. And it is believed the same rule should apply to the case of one who claims exemption on the ground that the property which has yielded the income is subject to taxation or has paid the tax, and income derived from an independent source is not exempted from the income tax because it has been applied to the payment of a debt due for real estate, per 33 Century Diet, Voc. Chamber Trade, S** City of chased on credit, and upon which real estate a tax has been assessed and paid for the same period within which such income accrued. 36 Section 87. Proceeds of life insurance policies: money received from a life insurance company in settlement of a claim under a policy for the death of the assured would probably have to be reckoned as part of the income of the beneficiary or recipient, if not specifically exempted. But in pursuance of a humane and wise policy, the income tax laws have generally provided for the exemption of such funds. The Act of Congress accepts from the description of taxable income the proceeds of life insurance policies paid upon the death of the person insured, without any limitation as to the amount. The statutes in Wisconsin exempts insurance to the total amount of $10,000 received by any person or persons legally dependent upon the decedent in payment of a death claim by any insurance company, fraternal benefit society, or other insurer. It will be observed that insurance money is not exempt in the hands of any beneficiary who is not legally dependent upon the decedent, and that any amount of money so received above the sum of $10,000 is taxable as income of the year, without regard to the relation between the decedent and the beneficiary. It may also be remarked that, under either of these statutes, money received by the assured himself, as in the case of accident insurance, will not be exempt, since in theory it merely takes the place of what he would have earned during the period of his disability. But as to life insurance proper, the Act of Congress also exempts payments made by or credited to the insured on life insurance, endowment, or annuity contracts upon the return thereof to the insured at the maturity of the term mentioned in the contract or upon surrender of the SS Lot v. contract. Money so returned, it is provided, shall not be included as income. Section 88. Exemption of fixed amount of income. All income tax laws have wholly exempted incomes below a certain fixed minimum and allowed the deduction of a like amount from incomes large enough to be subject to the tax. The object is to relieve from the burden of this tax those persons whose annual earnings or gains are no more than sufficient to maintain a decently comfortable existence, and to permit persons of larger means to deduct a sum which may represent the ordinary living expenses of the average family, so that the tax may not fall upon the necessaries of life or a reasonable share of its comforts, but only upon superfluous income. As corporations and partnerships have no corresponding expenses, they are not entitled to the exemption of a fixed sum. The amount of this fixed exemption has varied enormously in different localities and at different times. In the European countries deriving a revenue from this source, it is very small, as, for instance, in Great Britain, $800, in Prussia, $214, in Norway, $270, in Denmark, $540, in Austria, $250. Under the Act of Congress of 1861, the exemption was $800. This was reduced to $600 in the Acts of 1862 and 1864, but was raised to $2,000 in the Act of 1870. In the Act of 1894, it was fixed at $4,000. The income tax law of North Carolina exempts incomes below $1,000. In South Carolina, the exemption is $2,500. In Oklahoma, $3,500. In Virginia, $1,000. In Hawaii, $1,000. The Massachusetts statute taxes the excess above $2,000 of the income from a profession, trade, or employment. The Wisconsin statute allows exemptions as follows. A. To an individual, income up to and including $800. B. To husband and wife, $1,200. C. For each child under the age of 18 years, $200. D. For each additional person, for whose support the taxpayer is legally liable and who is entirely dependent upon the tax payer for his support, $200. The provision of the Act of Congress of 1913 is that each taxable person shall be entitled to an exemption of $3,000, with an additional exemption of $1,000 in case the taxpayer is either a married man with a wife living with him or a married woman with a husband living with her. But in no event shall this additional exemption be deducted by both a husband and wife, and only one deduction of $4,000 shall be made from the aggregate income of both husband and wife when living together. It is, in fact, a common provision of income tax laws that only one deduction of the fixed amount is allowed to be made from the aggregate income of a family, the husband and father, if he makes the return, being required to include the separate income of his wife and of any of his minor children who may have independent sources of income. In the case of guardians making the return for their wards, the deduction is allowed to be made from the income of each ward, except where two or more of them are included in the same family, in which event only one deduction from the aggregate is allowed. Objection has been made to the constitutional validity of such a provision, but it has been sustained by the courts. Point 36 in regard to the federal income tax. Special provision had to be made with reference to taxing the income of the year 1913, since, prior to the adoption of the 16th Amendment, Congress had no constitutional authority to lay a tax on incomes, unless the tax should be apportioned among the several states. This point has been covered by the insertion of the following proviso, that for the year ending December 31st, 1913, said tax shall be computed on the net income accruing from March 1st to December 31st, 1913, both dates inclusive, after deducting 5/6 only of the specific exemptions and deductions herein provided for. esse Robertson v. Pratt, 13 Hawaii, 590. Chapter 8 Deductions and Allowances, Section 89.
All right, all right. That brings us to chapter 8, 8, 8, 8. And we are going to take a pause for the recording of today. Do some more later. Got some more reading to do. But we are a little bit, well, we're halfway through. It has been very enlightening. I am taking notes for when I make my treatise, my own treatise. And for those who want to get it, it will be on Black Site 32 on the file shop page. For those people that don't know, it's blacksite32.com. And also, you can find other good information on jamesclovett.com. Join you guys later. Join me later, and we'll talk to you later. All right, guys, take care. I appreciate you.